Welcome to Triangle BNI. Today's show is brought to you by Oak City Tech. They are professionals in the digital media world. We talk all the time about what is your message? Are you getting it out clearly? Are you getting it out to the right people? Because everybody seems to be an expert in that field. So you really need to go to oakcitytech.com, tell them what you're looking for because they are the experts. I know they'll be able to help you. Hi, everybody. My name is Mike Manning, and each week on Triangle BNI, we bring you a local small business success story. If you are not familiar with BNI, it is Business Networking International, the world's largest networking organization. Our little slice of heaven here in the Triangle is Raleigh, Durham, and Chapel Hill. And each week, about 30 or so, 32 chapters get together, a little over 500 members, and our goal is to help each other grow our business. And our small business success story is a repeat guest from just a couple of weeks ago. If you remember Alex Anderson, our favorite attorney these days, Alex is in RD 48. Their chapter's name is Next Level. They meet Thursday mornings at 8 a.m. in Cary. If you want to meet some serious players in the business world in Cary, please visit their chapter. But she is the owner and co-founder or founder of Anderson Legal. Alex, glad to have you back.
Much for having me back, Mike. This is a lot of fun.
Well, we had so much fun last time, and I joke with people. I this is my favorite part of the week is doing the show because I just like asking questions and learning stuff, and I need to be entertained. Basically, that keeps my energy level up and questions better. But I was so fascinated by our conversation of your legal background, and we've had a couple other lawyers on, but none that ever went to court on a semi-regular basis. And I know what we see on TV, and I know that's not what really happened. So I'm glad you came back where we can talk a little bit more about that. But just to refresh everybody's memory, Alex, and it's Aleksandra, Polish descent. We talked about that. Alexandra Elżbieta Kozlowska, right? Brought my notes from
That's
last time.
correct.
All right.
Yes, yes. And
And
now it's Alexandra Elżbieta Anderson.
Yes, but your maiden name was
Right.
Kozlowska. So, you were happy to marry into an Anderson because you didn't have to spell it, right?
Absolutely
Yeah.
correct. And actually, since we're on the topic of courts, it makes it a lot easier in court to have your name be Anderson as opposed to Kozlowska, because most people refer to each other by last name in court.
Oh, really?
Yes,
Oh, so they refer to you as Miss or Mrs. Anderson?
that's correct. Yes.
Oh, okay.
Sometimes attorney Anderson, that's become more and more common.
Attorney Anderson.
Yes, and so I was actually talking to another friend of mine about this because I said to her, I'm seeing this trend of attorney Anderson, and our theory, and this is just a theory, is that this is a part of making sure that we don't assume which gender somebody wants to be characterized at. So whether he, she, them, there, I
Yeah.
think attorney Anderson just seems safer for some people.
Yeah, and this is and we're not gonna go into it today because I'm learning I feel like I'm learning and listening more as I get older, and it's a generational thing, and it's hard because there are men and women, and I want everybody to be comfortable and happy, and if you wanna be called or identified or acknowledged as this, that's wonderful, and again, it's just a generational thing for me, so it's interesting that that's coming into the courtroom. Um, yeah,
And
that's
that's just a theory as to why
okay.
there's an increase of the use of attorney.
Yeah.
I personally do not address people that way because I feel like there's a better way to address somebody other than attorney.
Could you tell the judge you're fine calling me Mrs. Anderson?
Absolutely. And I think most judges still stick with
Yeah.
Miss Anderson or Mrs. Anderson.
Okay. Um, and what I learned having been married, see, Becky and I are 35 plus years now, just the hassle it is. First of all, women have a difficult life. My kind should acknowledge that. So, most of you are marrying my kind, and that brings its own problems. but you're giving birth to children, which we are not. But you have to change everything when you get married if you want to take your husband or partner's last name. And that's just a royal pain in the butt, isn't it?
It is. It took several months to do it.
Yeah.
Yep.
And if you wanted to go on a cruise for your honeymoon, okay, I can't change my name yet because I don't need that working in the system. And I get to the ship and they don't let me on because, like, well, we don't have you under this name. It's just not fair.
Yep. So I waited until after our honeymoon to change
Yeah.
it
Yeah.
so that everything was the same throughout all the systems.
And I can assume you wanted no part of a hyphenated last name.
No, that really would have caused a lot of trouble.
Then your initials would be AKA, right?
Yes. Yes. Yes.
Which would bring on another, like, wait, hang on a sec. Is this a joke?
That's right.
Oh, what a mess. All right. So legally, let's talk about Halloween. All
All
right.
right.
All right. So as
Okay.
a mom, first as a mom, this was your
Yes.
son Everett's first Halloween. How did that go?
It was his first time trick or treating.
Trick or
So,
treating. Okay.
yes, first time trick or treating. And he's been planning for this for months. I think he's been talking about Halloween since July. We're really not quite sure how it came about, but he's been talking about it. And he planned out his costume. He wanted to be Spider Man.
Mm,
And so the entire family got involved. My husband put together a Hulk costume. I had a Wonder Woman costume. It was
nice.
all set and ready, and he wore his Spider-Man to school. And we're getting ready to go out, and he just takes his costume off and, no, mommy, I'm not gonna wear it. So it was a little bit of a surprise for me, and he ended up going as a skeleton, which was great. I think he was a lot more comfortable as a skeleton, but there was a lot of anticipation and planning going into the Spider-Man costume that never really came to fruition. So we're in our new neighborhood. We're living in a neighborhood that's just getting finished built. And so it was a good way to meet all the neighbors, but my chances of actually interacting with people were very low because Everett was literally sprinting from house to house. The first three houses, it took him some time to warm up and understand what's going on, even though he's been talking about trick-or-treating for months. But at some point, it really became a workout to keep chasing after him.
Did he understand the goal is to get to the front porch and get the candy, or the goal was just to get to as many houses as possible?
Oh, the candy was most certainly well understood by him. And I have to say, I was pretty proud because he did not take any road candy. There was no road candy eating. He waited to get home. And then eventually we had to wrestle the candy bag away
Yeah.
from him.
All right, so here's my, older parental advice to younger parental units, okay? It is your job to inspect the candy after your kids go to bed to make sure everything's safe,
Yes, yes,
and I
yes.
was hyper aware that the M&Ms that my boys got were always safe, so I had
Oh,
to
yes.
inspect
Yeah.
the M&Ms, so
Yeah. So far, I'm doing quite well after the taste test, but I think more taste testing is in order.
right, and he's not gonna remember.
No, he'll have
Yeah,
no idea. Now, I do have to admit, we went trick or treating with his grandma, and his grandma and I, we were both kind of whispering to each other, I really hope he goes for the
yeah,
Reese's, go for
yeah.
the Reese's. But then he'd go for things like Whoppers and Dots. And I would have selected a very different type of candy.
I A couple weeks ago, I took some candy to a group of people, and the only thing left were the Whoppers out of the bag, so I don't know if they
You know
realized they're
what?
at the
You
bottom of the totem
steal
pole, yeah. Yep.
chocolate. If you know, that's
But those are always fun, and then I'm the middle of 3, so I have an older sister and a younger brother, and as we got older, what we would do is we would come home at night, lay out all the candy on the floor, and start trading,
Mhm,
and that
mhm.
was always fun because, again, I'll cut a deal for M&Ms, that is not a problem, I'll give away everything else for M&Ms. Can we ask if Halloween is big in Poland?
Sure. It's somewhat of they know about it, and
Yeah.
I think that, through movies and whatnot. However, in Poland, November 1st is a big deal because that's All Saints Day,
Mm.
and Polish is traditionally a Catholic country, and so All Saints is really celebrated there. And so I think that the adaptation of Halloween has been quite slow because a lot of people are turned off that it's a little bit disrespectful, I think, is the my understanding of how it's viewed. So it's understood that it exists, but not that it's being adapted into the common culture.
Okay. All right. You're glad to then have him go as a skeleton and a Spider-Man. Do you think this will be a trend or an indoor costume and an outdoor costume moving forward?
I hope not. But I think it remains to be seen.
Yeah. Legally, if somebody trips down our steps after
Mhm.
getting candy and we have no tripwire or anything like that or it's lit there, tell me there's no cases that have ever been brought to your knowledge for somebody falling and tripping on a yard for trick or treating.
I have to say it depends. I have never come across a case that involved trick or treating. Um, However, there may be some liability involved if somebody that is allowed to be on your premises, and it's implied, I think, that a trick or treater is allowed if you
Yeah.
have your lights on and you've got your bowl out, and gets injured, then you may have had some sort of duty to keep them safe.
All right. Okay.
And the thing about the law is I can never give you a yes or no answer.
No.
Always, it depends.
Yes, because yes, and I follow you on that because we've seen things get passed that's like, hang on a sec. Again, I go back to the McDonald's coffee lady.
Yep.
Kind of know the coffee's hot, kind of know that's a sensitive area. So you really want to mix the two. But, anyways, I digress.
Okay.
So going to court, and we
Yes.
talked about last show, at some point in time in the dealings with a client, you're pretty aware that this is headed to court.
Yes, generally speaking, though I have to say, many cases settle when you don't expect them to.
Yes. But when you know a case is on the docket, it's headed to
Mhm.
court, and it actually the morning of, there's been no agreement, no nothing, and you know, "Hey, I'm getting up in the morning and I'm going to court."
Yes, yes.
When you know you're headed to court, what do you, as a lawyer, have to prepare for logistically when you go into court? Is your client with you? Do you have to know who the players are? What's that like?
Absolutely. So that there's a lot of parts to this answer. So just about regardless of what sort of hearing or trial it is, it usually takes at least days of preparing the case law that you'll need, and also sometimes preparing the exhibits. Um, what happens in court is more often than not, you'll need to make some sort of argument and you'll need precedent to support your argument. So we bring case law, so printed cases, and you usually need at least three copies, one for yourself, one for the judge, one for the other side, because you can't hide whatever it is that you're trying to use to make your point. Um, and so you have to make sure that you have case law that's on point. And a lot of times that takes anticipation as to what the other side's going to present. There's also exhibits you might need to bring. You may need to prepare your client for their testimony. Not all hearings involve testimony. Many hearings are just on the documents, but some do involve testimony. And regardless of how long the trial is, client preparation is usually quite lengthy because few people have testified in the past. And even if you have to prepare them for the dynamics of the case and for how to tackle this particular testimony. And, a lot of people ask, well, do you tell your client what to say? Well, no, we practice them saying it, but they're always expected to tell the truth. So a lot of times a client will tell me, well, what do I say? Well, you tell the truth. I can't represent you if you don't tell the truth. Um, and there's a lot of notice provisions. If it's your hearing that's on, you need to make sure that you give the other side proper notice. So mail or email a written notice of when and where the hearing's being held. And usually you have to do that at least 5 days before the hearing. Realistically speaking, that usually happens more like at least a month before the hearing. And also, just the day before, you got to make sure you're on time, dressed right, because decorum in court is very important. Um, and just be ready to go.
If you have a client, let's say there's no witnesses, you are just presenting your side to a judge, and then there's the other side. Are there many other people in the courtroom at that point?
That depends. Usually, what happens, and we'll take Wake County as an example because that's where I do most of my work. Is that there's calendar call, and what you're describing is a motions hearing. So it's mostly just motions, and the judge will go down the list of items that are on the docket for the day. And it depends on the judge as to how they want to hear the cases. But usually they ask the parties, how long do you anticipate this will take? And most people significantly underestimate how long their hearing will take. And then they'll take the quicker cases earlier on and leave the ones that take longer for later. And I have to admit, somehow I usually end up at the bottom of that list.
Should a class in law school, well, is there a class in public speaking or in debate or in acting?
So I think that law schools significantly underemphasize those skills. I had just one class called trial advocacy, and that was basically we practiced portions of the trial throughout the semester. And then at the very end of the semester, we did a mock trial and we had a mock jury. And there was a mock winner and a mock loser. But that was just one semester in one class. And most of the rest of law school was really just the theory behind the law and reading case law. I think something that a lot of, well, all new attorneys lack when they leave law school are the speaking skills and also just the practical skills of, what documents do you need to send out if you want to commence a summary judgment proceeding? What do you do? And I think most young lawyers don't have training in that unless they've worked at another law firm during law school that did that and taught them how to do it.
Now, TV law prepares us for nothing of what real law is like. I think we all can kind of agree that but of course, every case has to be buttoned up within the hour. So we know that's not for real. But
Yes.
when you know you've got a case and you know it's a jury trial,
Mhm.
we see on TV how they interview these jurors. They ask
Mhm.
them, so how many questions do you get and how much time can you have to figure out if you want that juror on that trial?
You know, I have to say, I have to look back because it depends on state versus federal. And it's actually been a while since I've had to do a jury trial because it's so rare. You get a number of questions, you get a number of disqualifications that you can have. Um, some are for cause, so there's good reason for you to disqualify them, and others are for no reason whatsoever. So long as it's not an illegal reason, like you're discriminating against somebody because they're a protected group. Um, and every once in a while, there is indication that that has happened, and that is addressed throughout the court system. But it'll all start off with the judge asking questions. And that kind of gives you a preliminary understanding of who the jurors are. And I've done some research years ago on picking jurors, and the conclusion is, yeah, you can use all sorts of science to understand who's going to be a strong jury for you. But in the end, it's as good as random, no matter what you do.
If your client is male, female, black, white, rich, poor, young, old, do you want more or less people like that on the jury?
Generally speaking, in my mind, I would want my jury to relate to the individual that I'm representing or corporation. That is, I want them to understand what my client is going through, essentially. So, yes, that is generally how I would pick to make sure that they understand my client. However, my selections are more so based on the individual's experience in life. So, if we are doing a landlord and tenant trial and I represent the landlord, I probably will not want somebody who has been evicted previously. But I may want somebody who owns a rental
Yeah.
company or some rental spots.
No, and I understand that because a lot of times you would rather have somebody that can process information versus
Yeah.
an advocate for an issue, right?
Exactly. Yeah. Because the jury is really supposed to answer a factual question, because a lot of times there's issues of fact. If it's an issue of law, that's addressed by the judge. And very often you can get that resolved prior to trial at a motions hearing. But the trial is really to identify the facts of what happened. And so the jury, when they go in to deliberate, will get a questions sheet and they have to answer the question of
Oh,
what happened here.
interesting. I've never heard of that before. And are jurors allowed? I believe they're allowed to take notes now, correct?
They are. They have, they'll have copies of the exhibits. And I have to say, I have never been on a jury. However, I do feel for jurors
Mhm.
because unless you're going into a shorter trial, um, most if it comes down to the point where there's a jury, it's going to last some time. And there's just so much coming at you that it's really hard to keep track of what it is that's important. Um, and oftentimes, if I can, I opt to have a non-jury trial. Um, in North Carolina, if one side demands a jury trial, then you have a jury trial. But if neither side demands a jury trial, you will not have a jury trial.
Now, 3 of the occasions where we see these TV and movie lawyers, earn their money, one is with a very demonstrative objection. The other
Yes.
one is they ask a question and the other side, stands up and objects, and they go, I'll retract the question," or "I take the," however they say that. And then the
Mhm.
third one is, "Oh, I just got this information, your honor." So
So
let's
just
yeah,
got this information is
yeah.
the least common.
Okay.
Absolutely least common, because by the time you've made it to trial, you have had plenty of opportunity to discover it. However, that doesn't mean it doesn't happen. Every once in a while, you will get what I like to call, and my former boss like to call, ambushed, where the rules require the other side to provide whatever exhibits they'll have or affidavits they plan on presenting, and they never presented that to you prior to trial, despite being required to do that. And then all of a sudden at the hearing or the trial, they try and introduce that to the judge or the jury. And at that point, that is a basis to object to it. So that could be new information. However, you're really, I think the TV shows, make it like you're going to have this key fact and this relevant, and that's just,
Yeah.
it's very, very unlikely. And if it's the case, in more often than not, you either didn't do your job or the other side did not do their job.
If you
Um,
if you know I'm going to be a witness
yes,
for your opposition, your client is the defendant, and you know I'm gonna be a witness for the prosecution, and you're allowed to interview me before the trial, correct?
that's correct.
Alright,
It's called a deposition.
right, and I am under oath,
Yes.
right? And I give you the answers that I saw the blue car run the red light, and I give you all these, and then I get to court that day, and all of a sudden my story changes a little bit.
Yep. And
Are
so, mhm.
are you allowed to say, "Mr. Manning, that's not what you told us earlier"? How do you bring that up?
Yeah. So depositions, you are allowed to have them transcribed. So you have the court reporter sitting there and typing up what's being said. And so that's not a requirement, but I have never done a deposition, nor would I recommend that anybody do a deposition without a court reporter present. So everything that's being said should be recorded in writing. In certain cases, and I've done this once, or actually I've done this in one case more than once. You can also have a recording, a video recording of the deposition. And so at trial, more likely than not, if it doesn't match what you previously said, you pass up the transcript of the deposition to the witness and you say, okay, well, Mr. Manning, were you not deposed on this and this date? And did you not testify this and this? And can you read out the line number 13 on page 3? Isn't this directly in context, in contrast to what you just told us? And so that is really why you do your deposition. You do your deposition to figure out what the person knows, to make sure that they stick to the facts when they're testifying, and also so that they cannot submit any affidavits that do not say the same thing as what their testimony said.
Are you allowed to call a witness that has not been properly introduced to your opponent?
Prior to trial, you have to disclose a witness list.
Mhm.
So you do not need to depose your witness. You are okay to proceed so long as that's okay with you and your client. But you do have to introduce a witness list. And it is grounds not to have the person testify if they were not included on that list.
And the other thing we see in the courtroom when there's a jury trial is you attorney types looking at the jurors and making this impassioned plea of how right you are.
Yeah, so that's called an opening statement. And that both sides get to do an opening statement. And that is not supposed to be an argument. It's supposed to kind of show the jury what they expect to hear and why they should rule in your favor. And I have to say, often those statements can be a little flat, but I think that I have seen and done some fairly fiery statements to try and show that, well, to show that I believe in my case. Because if we've gotten that far in the case, then I need to believe in my case.
And do you get a couple of minutes? Is there a unwritten rule on how long you get for those opening statements?
Uh, you know, I'm not quite sure.
Mm. Now, the other thing we see on TV is when I'm on the witness stand and you know you've got me. Okay.
Yep.
And then you kinda walk away from me asking me the question, and you're looking right at the jurors as you're asking me the questions. Like, "Okay, jurors, I'm looking at you right now because he's about to lie, so I'm gonna let him do that." But so do you move around the courtroom much when you're, questioning a witness?
So when you're questioning a witness in North Carolina, you actually have to be seated at your seat. You cannot move around.
Oh, well, that's
Only
boring.
It is the only time you can get up is to pass up an exhibit. And you actually, whenever you go past that desk and you go up closer to the judge, you have to ask for permission to approach, whether to approach the judge or approach the witness, because otherwise you might get tackled by the deputy that is overseeing that courtroom.
So Rusty the bailiff who protects Judge Judy, that would be his job is to tackle you?
That's correct.
I
Yes.
like that. See, that should happen more. I like that.
Now, there's an element of decorum there, of
Yes, yes.
course. However, I have seen it where the deputy, kind of gently stood up and
Mhm.
said, "Whoa,
Yep.
you haven't asked for permission." Um, because there is an element of protecting the judge
Mhm.
or the witness
Yep.
there.
Are you allowed to treat the witness as, quote, "hostile"?
Oh, yes.
Okay, we love that on TV.
Yeah. And you know what? It's fun. And it's a hostile witness and a witness that is being presented by the other side can be, you can ask leading questions, which means a leading question would be, isn't it true that on Friday the 5th you went to Target? Whereas, a non leading question was, where did you go on Friday the 5th?
Okay.
And so the idea there is that, their answers would be not very long, and yes or no generally. And there's a lot of strategy involved there.
Now, everybody's got those family members that would or wouldn't make a good witness. First of all, can you remember everything you saw? And most people probably aren't that good with remembering details, especially if it's 6 months later, right? But my youngest son and I are very much alike. If you ask us one question, you get 6 answers, whereas my oldest son, you have to ask 6 questions just to get that one answer.
Mhm.
So
Mhm.
which kind of witness do you prefer?
The witness that doesn't say much is often the best witness. You want your witness to be honest, but also just to strictly answer the question. Um, and oftentimes, I'm actually very surprised as to who makes a good witness versus who doesn't. I recently represented an entity where there was somebody who was on the board that was testifying, a former officer and an employee. And I was told by the leadership, this employee, she means well, but you're really going to have to train her. We don't see her doing well on the stand. And she and I did one run through, and I said, you know what? This was actually the easiest testimony prep we've done. You've got it. Your answers are right on point. You're honest, but you're not saying too much, you're not saying too little, you're professional, you got it. And then when we had to prepare the officer, and this is not me saying that he didn't have his strengths or he didn't have his abilities, but there's just a specific way of doing it. We had to really practice a little bit more of how to answer questions, to make sure that he is not saying something that not only is not true, but hurts him.
And
Um,
going back to the target question about the leading question, the answer to the question is yes and just yes, not, "Yes, I went there. I had a short list. I was between meetings, and I thought I'd jump in there because the rest of my day was busy."
that's correct. Exactly. Yeah. Yeah. And a lot of times, some witnesses will fall for um, a cross-examination kind of pattern that the other side will use. So using leading questions get you to say a lot of yeses, 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 and then they ask a question that they really want you to say yes to. You probably shouldn't because there's a discrepancy where a yes is not warranted, but they'll catch you there and you might not even realize. So you got to take your time and really think about what you're answering. And I guess it's interesting just going back to the good witness versus bad witness. One of the biggest trials that I've ever done involved a company that is not only nationwide but also in some of South America. And there was there was a number of individuals that were going to be witnesses for this company. And we had general counsel was going to be one of the witnesses, and the other one was a higher ranking employee. And again, we had concerns with respect to this employee, me and the other attorneys that were working on this case specifically. And with general counsel, we kind of decided, well, he knows the drill. He himself has been a litigator in the past and only went on to be general counsel after about 20 years of litigating. So we won't have to spend as much time here. And during our practice times, both witnesses did very well. We were very satisfied. And when we went to trial, the employee was very professional, very controlled, explained things in a way that was very easy to explain. And we felt like he really did a great job for us. The general counsel, one of the first things that he did was actually insult opposing counsel on stand. And he would do it repeatedly so. And we had to take breaks and say, hey, stop doing that. We talked about it. You can't be doing this. And every time he'd say, okay, all right, I get it. I won't do it. And he'd go back up and do exactly the same thing. And so walking out while the jury was deliberate, well, for days throughout the trial and while waiting for the verdict, myself and the other attorneys involved, we were chatting about, well, at least we've got this employee witness who did a good job, and in this general counsel, well, hopefully he wasn't the boots on the ground, so maybe it won't hurt us as much. Well, the trial did not go necessarily exactly the way we wanted them to. And towards the end, you have the opportunity to interview the jury. And we were shocked to find out that the jury could not stand the employee witness. They found him condescending and not trustworthy, whereas in our eyes, it was the complete opposite. They really had nothing to say about the general counsel witness. He was just kind of, didn't have a bias towards him whatsoever, which is
Yeah.
very much the opposite of what we expected.
And that's consistent in small business. Your clients know your business better than you do. So
Yeah.
it's funny. When you are sitting at the table with your client and
Mhm.
your opposition is questioning another witness, whoever they are you looking at the jury during that time that your opposition is questioning any witness?
You know, generally speaking, you should not look straight at the jury. It's probably you really should not turn your chair or your head and just make it seem like, they're the audience and or anything along those lines. It's not, you're not going to be punished if every once in a while you glance at them, but they're really sort of supposed to be flies on the wall is probably the best way to describe it.
Mm.
And you really need to go out of your way not to interact with them. So a lot of times we actually ask the judge to explain to the jury, if you come across the attorneys in this case in an elevator or you run into them at lunch, please don't be turned off by the fact that they ignore you because they're supposed to do that. We really need to keep that a very strict rule that there is no interaction with the jury.
Do you at any point in time, though, when that questioning is going on, Would it be helpful to see any kind of reaction from the jury to a particular question or line of questioning?
Absolutely, and I have to admit, I do glance over when I notice that something
Mhm.
keys coming up as to how people respond.
Yep.
Um, and sometimes it's indicative and other times it's not.
Do you when that line of questioning is going on and you're sitting at the table with your client, what interaction do you and your client have, either whispering as we see on TV or passing notes to each other, anything like that?
You're really not supposed to talk while the other side is going. And every once in a while, I will allow the client to whisper into my ear, or we will pass a no, but we try and keep it very discreet, not to be disrespectful. Um, a lot of that kind of depends on the client's personality,
Mhm.
and that they feel like, that they need to provide a lot of input here. But it is very much my job to be ready and prepared, and know the facts inside and out, maybe even better than my client once we get to that point.
Do you enjoy questioning a witness for the other side who thinks they're just a little bit smarter than you and they're gonna show everybody that during the line of questioning?
That's the best part. Yes. I honestly, I think cross-examination, is probably the best part of litigation, and it happens extremely rarely because trials happen extremely rarely. There are trials that happen in North Carolina. There are many trials that happen in North Carolina, but if you look at the percentage of cases, at least in my practice area, which is, it doesn't involve personal injury, it doesn't involve family law. Very few of my cases go through to trial.
But every now and then, when that person thinks they're just a little bit smarter, you just can't wait to start
Oh,
talking to them, right?
yes, absolutely.
And do they general how do they end up messing things up when that witness who thinks they're so smart, how do they end up messing it up?
Obviously, there's many ways of doing that, but what we just talked about, their deposition not matching what they say, is a very common one. um not being inconsistent in what they said in their earlier testimony is a very common one. um and a lot of times, just the way that facts are being presented, where certain nuances are skipped, certain documents are not introduced, where you can really tell a very different story than what was told on direct examination, where their attorney was questioning them. And we have the jury, or if it's a bench trial, so meaning the judge is the decider on the facts, to decide the facts. But I think that something that in the end is the takeaway is that the facts are in the eyes of the beholder.
Do you have to object much?
Oh, yes. And in some cases more than others. There's, certain attorneys that really stick to the rules of evidence, or other requirements, and others where I need to object more than in other cases. But just because I'm objecting doesn't mean that that attorney doesn't know what they're doing, or that it's a serious violation. Most of these objections will probably be somewhere in the gray as to whether or not they need to be made. And really, the key with objections is that you do object so that you got them on record. So the court reporter or the recording, because a lot of times in courts in North Carolina, proceedings are recorded as opposed to transcribed, so that if things get appealed and they go to the Court of Appeals, maybe even the Supreme Court, it's on record that you objected, and you can still pursue that objection to try and change the outcome. Whereas if you do not object, you've waived that objection, and you can't come back and say, well, what happened on the second out of 10 days of trial, now I want to object to it.
And how often the other thing we see on TV is where the judge will call both attorneys up to their bench for a sidebar, whatever it is. How often does that happen?
That does happen. And I think that, the more contested, the more fiery things are, the more likely that is to happen.
Do you enjoy finding, and don't incriminate yourself, please, but do you enjoy finding where the line is and just how far you can move that line a little bit on questioning and just theatrics or anything in courtroom to make your point?
You know, I think that it's not necessarily finding the line, it's advocating on behalf of your client. And so if it seems like, it's not a blatant violation of the rules of evidence, the rules of civil procedure, the law, and it's important to do for the sake of your client, then you kind of test that waters. Is it going to get objected to? How's the judge can always rule on it, right? That's what the judge is there for, but it's your job, my job, to advocate for your client. So if it's not a blatant violation, I often think that's just a good way to advocate for your client.
And then also at times planting a seed in the juror's mind, whether it was sustained or anything like that. You just want to plant a seed. Yeah.
Yeah.
Do you wish more or less of more or fewer of your cases went to trial?
I wish that more of my cases went to trial. I don't wish that all my cases went to trial, because trial really is very rare. Hearings are much more common. A lot of cases get resolved on hearings. So I do go to court for hearings most of the time, is why I'm in court. However, trial, there's a very fun element. There's a thrill involved in trial. And I wish I could do that a little bit more. If all I did was trial, I probably would not be in this field, because it is, the bigger trials can really require, burning the midnight oil for months on end. And it can become very taxing in many ways.
Well, folks, if you or someone is about to run into trouble and they need an attorney that they may or may not have to go to court for, please look up Alex. We've been putting her phone number up here on the screen. And Alex, what's the website? Best way for them to get in touch with you other than that phone number?
www.andersonlegalnc.com.
All right. So if you know anybody that's about to find some trouble coming their way, or they've already found it, please reach out to Alex. I know she'll be able to help you. Alex, this has been a blast. I know TV, and I know most of it's not true, and you further confirmed that even less of it is true of what I thought wasn't true.
And thank you so much for having me, Mike. This was such a great time, and I really enjoyed sharing with you and your audience.
Well, good. I was highly entertained today. Glad to have you back. And folks, we'll see you next time on Triangle BNI.
You are tuned to the Nissan Communications Network. If you tuned in too late, you can always watch each program in its entirety or download an MP3 audio file of it in the archives section at nissancommunications.com. Don't forget to subscribe to our YouTube channel, follow us on Twitter, and like us on Facebook. Sponsored by StreamingGear.com, Carolina Apparel, and DeltaForce.net.